In the court of law, defendants are expected to follow basic rules and maintain orderly behavior. But when they act like the law doesn't apply to them, they find out how little patience judges have. From skyrocketing bond amounts to excessive use of force, this is when judges shut down sovereign citizens with massive sentences. Just like it happened with this first guy, who had to learn the hard way what happens when you make a calm judge mad. For that, we have to travel down to Nucla in Montrose County, where Judge Stephen Schultz is about to hold a sentencing hearing for a defendant who has been difficult, to say the least. The defendant chose to attend virtually alongside the rest of the council, but it's clear he has no desire to comply with the trial.
Mr. Dozier, we'll unmute Mr. Bama.
Oh, yeah. You're my old neighbor. Sorry, Your Honor, I'm here.
Yeah. Mr. Dozier?
Yeah. Yes, sir.
You need to stop talking passerbys. They're not part of the hearing. It's distracting.
Well, you muted on your end. You guys could do it last time.
Hey, Mr. Dozier, Mr. Dozier, I've allowed you. We're going to go
Your
on.
Honor, do you have your gown on?
We're going on.
Are you wearing your gown? Are you wearing your gown right now?
Hey.
Okay, so we are now on the record.
Okay.
No,
You are
I'm not.
Yeah, with the gold Prince flag in the courtroom, right?
Hey, Mr.
You listening
Dozier,
to me, Your Honor?
Mr. Dozier, I've asked you to mute and the judge has asked you to mute. Can you do that from your end or do we need to do it from our end?
He can do it from his. He's got the computer right in front of us.
Usually, sovereign citizens tend to keep quiet and avoid addressing the officials while they cite make-believe laws. But this guy decided to do the complete opposite. Just when the judge thought he would get some peace after muting the defendant, he decided to pay the court a visit and continue his expletive rampage.
And for the record, I've muted him right now because as I tried to address him, he spoke over me and was speaking inappropriately. So I'm going to make a record here. For the record, he just disconnected.
However, keeping quiet was the last thing he did, as he doubled down on his disruptive behavior by making physical threats against one of the bailiffs.
If you have outbursts like that again, you can be held in contempt.
If he touches me like
Mr.
that,
Dozier,
I'm gonna let the f***ing hair out. You hear me?
do you hear me?
Yeah.
His outburst quickly turned into a psychotic meltdown, as the judge just stared him down.
Okay, Mrs. Farr, I'm going to address him.
You're gonna address me?
You may.
You ain't
not.
gonna dress nothing on me, motherfucker.
Okay.
You've got me undressed enough, haven't you? Every time I go to jail, I gotta undress.
Mr. Dozier, I'm advising you to exercise your right to remain
You know what
silent.
I've been through in my life. Do you know what you do every time you put f***ing handcuffs on me? You do that! I like you!
You need to be quiet.
Stop doing that to me then!
You need to be quiet.
Alright, because I can f***ing go all the f***ing way.
This went on for a few minutes non-stop, until the judge finally began charging him in contempt of court, which just piled on as he kept spewing verbal poison.
Done. Alright, I'm done. You can
no,
talk.
No, I'm going to talk.
No, I'm done. You can talk now.
Because this behavior
It's fine!
is inappropriate.
There ain't nothing wrong with it.
It's
Have
contemptuous.
you been to military court?
It's contemptuous.
Have you fought in a war? Time I
You've
warned you.
now
Listen,
told
I
this
ain't gonna warn
court,
you again.
F you,
Right, there you go.
called me a motherfucker,
Let it out.
okay?
Yeah, you goddamn rights I did.
That is,
Keep putting handcuffs on me, motherfucker. You might as well. You want me to bend over the table for you?
His attorney tried to advocate for him, but the judge had a much more concise ruling.
Judge, I apologize for interrupting. I would just ask the court to advise Mr. Dozier that while we cannot represent him, I believe he has the right to a civil attorney for a contempt proceeding.
not for direct contempt. I can summarily sentence him for the contempt of the court. And this behavior, the manner in which you've addressed the court, the language you've used, the fact that you have spoken over the court, all of it is offensive to the dignity of the court. Not me, but the court.
And while this next guy could have gone off easy, he found out the hard way why bailiffs aren't to be messed with. Robert Peterson, a young man from Idaho, had been charged with a minor traffic infraction for riding his bicycle at night without a light. But from the moment he stepped in the courtroom, it was clear that he wasn't going to make things so easy as he walked up to the security check.
And I'd just like to know where your warrant is.
It's clearly posted on the entrance building.
What? Clearly posted that I have to forfeit my right to be free from unreasonable search and seizure?
Coming into this building.
Yeah, every person is. I'm not a person. I'm a man. I'm not subject to your jurisdiction, and the court has already confirmed that. I'm here for one purpose. All right.
You can submit or you can leave.
Well, I'll allow you to search, but I mean,
That has to go through the X-ray machine if you want to come in this building.
what does?
That folder.
That's fine. I mean,
That's what we're trying
I'll
to
do
get
that,
you to do.
but you will be charged a bill. You will be served a bill.
Once he made it past security, he sat in the back of the courtroom where one of the bailiffs had to confront him for continuing to record.
So there are no cameras in the courtroom.
Excuse me?
There are no cameras in the courtroom.
Yeah, there is.
No, you have to put that away.
No, I don't.
Yes, you do.
Under what authority?
You have to have a court order from a judge before you can have a camera in the courtroom.
Okay, well, I'm going to capture
No, you can't.
this on video.
You gotta turn it off.
It's for both of our protection.
Well, you have to turn it off.
No, thank you.
Then you have to leave the courtroom.
No, thank you. And you have no authority to
Are you here for
tell
8
me.
a.m.s or
For what?
what time's your court?
8 o'clock.
Shut the camera off now.
No, thank you. I do not consent to you touching me or seizing my property, so you need to
Shut
back
the
up.
camera off now.
I'm not doing anything wrong.
Yes, you
I'm
are.
holding you accountable.
After denying the request multiple times, the bailiffs had to escort him outside the court to continue questioning him. But that did not mean that he would act any differently.
Then you just step out, sir.
What's your first and last name?
I don't have a last name.
You don't have a last name?
No.
What's your first name?
I don't have a first name either. I've got a name. My name is Robert. You can call me Robert.
Once it seems things have been resolved, the bailiffs usher everyone back into the courtroom, but refused entry to Peterson, who was still recording.
I'm gonna go in and speak with the prosecutor. Excuse me.
Camera.
Excuse me. You're blocking my freedom of movement. Well, P. Barnes, you just admitted to me that you're violating my rights.
No, I'm not. You can't come in with the camera.
And he kept testing the chief bailiff's patience, who ended up giving him a shocking wake-up call.
And I'm gonna speak with the
You can go in
prosecutor.
there without the camera.
Well, please step aside. I'm going in.
No, you're not going in.
Don't touch me.
You're not going in, sir.
Let the record show that you just battered me,
Step back.
and you're using...
Peterson would be arrested and charged with 3 counts of battery and 1 charge of contempt of court, adding up to 2 years in jail.
He was facing 2 years in jail for battery and contempt of court.
The charges were later dropped as a result of a plea deal, but still had to pay a fine for his original traffic violation. But things can get much messier when the defiance goes from verbal to physical. Just like it did for 55-year-old Anthony Matthews, a self-proclaimed sovereign citizen from Dayton, Ohio, who was facing charges for driving with a suspended license. Given the nature of the charges and the type of hearing, it should have been a swift sentencing, but Matthews immediately filed several motions to challenge the authority of the court over him, something the judge was quick to dismiss.
Explain to you the rules here in the court. Let me explain to you the rules of the court, sir.
I did not care to take part in fraud.
As a result of his defiant behavior, the judge had to warn him and advised him to adopt a more civil posture. But Matthews kept escalating the situation.
You can be found in contempt if you continue to interrupt me. We'll proceed with trial with you in abstention, sir, and we're going to find you in contempt. What I'm going to do is give you...
That's the record respect. The court intentions coercion use coercion to...
You're interrupting the proceedings of the court, sir, and it is direct contempt. It is direct contempt, and we're going to take you into custody, sir. We will give you a hearing, and you'll have the hearing. We will find counsel for you.
Matthews was too busy arguing with the court deputies to notice that 2 off-duty cops, who were standing by, got up to handle the situation, serving a bit of blunt justice. It took several guards to finally take Matthews down and apprehend him as the rest of the court officials evacuated the scene. The next day, he stood in front of the same judge to face the newly added contempt charges, although his attitude was much different this time around. Despite all his attempts, there was nothing this next sovereign citizen could have done to avoid what he had coming. In 2018, Michael Crane made a request to change his plea from not guilty to guilty on minor burglary charges over a crime spree that took place in 2012.
It's my understanding that you wish to change your plea.
I've already told you that I'm willing to accept responsibility for all these charges. So that is what I'm telling you right now.
You're giving up your right to a jury trial where you'd be represented by a lawyer. Do you understand that?
I understand that, but I don't agree with that.
You're giving up your right to cross-examine or question any witness the state called. Do you understand that?
I understand that, but I don't agree with that.
This is fine and all, but Crane was simultaneously being charged with re-murders that also occurred around the same time in Paradise Valley, Arizona. He tried using his guilty plea to obstruct the process on the murder charges, as he chose to defend himself and kept barraging the judge with his sovereign ideology while he constantly refused to actually sign the plea.
You're giving up constitutional rights.
Which U.S. are we talking? Are we talking about the federal constitution of the District of Columbia, that U.S. Constitution, or are we talking about the States of the Union common law constitution?
It took almost an hour of ranting for Crane to finally enter the guilty plea, but even then, he refused to sign it as it would contradict his sovereign beliefs.
A trial or a choice for me to accept your plea? Given that choice, which would you prefer?
The choice to accept the plea only under my conditions. I'm not going to sign a contract that's going to send me to prison. Not voluntarily.
Ultimately, he was sentenced for the burglary charges, and it wouldn't be until 2019 when Crane also pleaded guilty to the murder charges as an agreement to take the death penalty off the table, but not without challenging the judge one last time.
I don't have a contract with this court. These are your laws, not my laws. These are your rules, not my rules.
The trial has dragged on for years as neighbors have waited on a resolution. And with Crane now pleading guilty, he'll avoid the death penalty, but not justice. With neighbors hoping this news will put an end to the horror and provide some sort of relief to the families.
Hopefully it'll bring some sense of closure for the family.
He's currently housed at a high-security complex in Arizona, serving 3 different life sentences. Something all these so-called free men have in common is that they always choose to represent themselves, no matter how weak their grasp of the legal system is. And Jamel Cromartie found out the hard way how bad an idea that is. See, in 2023, Panama resident was being charged for attempted murder in the first degree for his involvement in a shooting that took place a few years prior, which resulted in a man being left in a coma. He was also charged in trying to bribe the victim to drop the charges. Cromartie was offered a deal to serve a minimum of 20 years in prison, but he refused, despite being strongly advised by his attorney to take it.
My client had an offer from the state last week, and he did not wish to take advantage of that offer. My investigator and I went out to the jail, talked to him, went over things, explained everything to him. I gave him my advice, which was that I thought it was in his best interest to accept the offer.
His attorney tried to explain to him that he would be facing 2 life sentences for his crimes, but his strategy was to plead incompetence to have the charges lessened or dropped. Needless to say, the judge wasn't amused.
In light of the fact that Mr. Sullivan has made this new filing, and now you have your maximum exposure is 2 life sentences, do you wish to reconsider your choices with regard to accepting the offer?
I don't understand. I don't understand. And being that he's representing me, we haven't even worked the defense in this case at all, period.
Okay.
And plus,
let's take one thing. Do you understand that you've been off for 25 years in prison?
I don't understand, so yeah.
Then yes, you do understand you have a plea offer for 25 years in prison.
From there, he thought he knew better than everyone around him and made an even worse decision.
What are you asking for right now? What are you asking for?
I'm asking for him to be removed off my case.
Raise your right hand to be sworn.
The judge humored him for a while before sending his case to sentencing, and after only a 20-minute verdict, he was sent to prison with 2 life sentences. Yes, 20 years don't sound that bad now. This next case displays just how angry a judge can become after having to deal with a difficult sovereign citizen. Back in 2014, Delvon King was representing himself during a jury selection on weapons charges after being caught with an unregistered firearm after a traffic stop. Prior to this, King had fled the courtroom during a preliminary hearing and was required to wear an ankle shock cuff while appearing in court to prevent him from escaping again. The trial was presided over by Judge Robert Nally, who had retired a year before but was called in from time to time to hear cases. Shortly after the hearing started, King began his sovereign speech, explaining how the court had no power over him, which was immediately halted by Nally with all the tools at his disposal.
Stop. Stop. Mr. Sheriff, do it. Use it. All right, I'm going to take 5. Don't. Calms down, and I'll be back. Yes, sir. 5 minutes.
King was sentenced to 2 years in jail on the weapons charge, and no conviction was added to his record. But things weren't as easy for Nally, who was promptly banned from hearing any other cases moving forward, and was sentenced to a year of probation, to take anger management classes, and to pay a $5,000 fine. It didn't end there though, as King took his own legal measures and went on to sue Nally for $5 million in punitive damages. On the other hand, Judge Cedric Simpson is often revered for the way he handles difficult defendants while being appointed to Washtenaw County's district court. And that was exactly the case with Daniel McGough, a sovereign citizen who went up against Judge Simpson on multiple occasions for several minor charges, including failure to comply with officers of law and resisting arrest.
Sir, state your name. I'm here on a special appearance, Your Honor. Magoo is Easy Elastical Trust, registered in Jackson County, on a case number 2522246. Okay, is your name Daniel Magoo? Your Honor, that is the name you seek, and it is copyrighted and trademarked. Okay.
On this occasion, McGough was facing charges for driving while intoxicated as a repeat offender, for which he chose to represent himself, but went against every claim the judge made about the case and his charges.
You committed the offense of operating while intoxicated. Do you understand what you're charged with?
I do not.
You do not understand
There
that?
is no eyewitnesses or corroborating witnesses at all.
I'm not asking whether or not the proofs are there. Do you understand what you are charged with?
I do not.
Do you understand the notion of drunk driving?
I do not understand how I could be charged with something without a witness.
On your other cases when you represent yourself, so we'll just do it.
Are you talking about the case that's in federal court right now, Your
You are
Honor?
before a complaint in that case for a charge of operating while intoxicated.
Instead of flipping out, Judge Simpson used every one of his slip-ups against him.
Given that the defendant is talking in English, that he understands English, understands the nature of those charges and what he's charged against.
So malicious.
It did not matter how many times McGough spoke up during the reading of the charges. Judge Simpson kept his cool until it was time to remind him who had the gavel.
Do you wish to still proceed without an attorney?
I just want to know, where do you get your powers? Are you an Article 3 judge or an Article 6 judge? Where are your vested powers? Can you answer that?
An attorney.
You can't even answer me what your powers are.
You can look it up.
No, you guys disconnected my access to any kind of law library or anything. You are an Article 6 judge under the Michigan Constitution. You have no authority to deprive me of my rights. Yeah, and who restricted my phone calls?
Conference. You know what? You're going to have to stop interrupting. I will give you an opportunity. You've been before me before. I will give you an opportunity to say whatever you want to say. But I'm not going to have you interrupt me, and I'm not going to have you interrupt people when they're talking.
Due to being a repeat offender, posing danger to the public, and obstructing justice, the judge took the liberty to up his bond from $10,000 to $50,000.
The court does believe that not only does the defendant pose a risk to the public,
no
I
victims.
do believe that the defendant is a risk of flight given those circumstances, and has indeed, or at least is charged in this case, refused to obey or plea given those circumstances, would in each case raise the defendant's bond, grant the people's motion. Defendant's bond in each matter is set in the amount of $50,000 cash here.
Now, one thing is defending yourself in court, and that is exactly what Florida resident David Hall did during his bond hearing in what remains one of the most bizarre trials of a sovereign citizen. Hall was facing several traffic charges, including driving under the influence and doing so with a suspended license. Despite bond hearings only taking a few minutes to conclude, it did not take long before the proceeding judge found out just how long of a trial it would be, as Hall started interrupting him from the very beginning.
Mr. Hall has declined the services of the public defender, Your Honor.
Mr. Hall, DUI, expired driver's license.
Good morning, Judge, I need to say how I'm appearing today, sir.
Hold on, wait, let me finish. Hold on.
What the judge didn't realize was that he wasn't even speaking to Mr. Hall at all.
Today I'm appearing as the agent and settler for David Hall.
Okay, could you get Mr. Hall for me then, sir? Where is he?
I go by that name, sir. My name sounds exactly like the defendant's, and I'm here to settle that matter today.
So are you and David Hall one and the same person?
I'm not a person, I'm an individual. David Hall is a person,
Okay.
I am
Are
the
you
agent
and
to that
David
name.
Hall one and the same individual?
I go by the name David Hall, sir, and I'm here about that matter today.
Okay, so
instead of reprimanding him, the judge chose to humor him for the remainder of the hearing, but not without having some fun of his own.
So this is what we're going to do. The person who goes by the name of David Hall is standing in front
I'm
of
the
you.
individual.
You're
I am
the
an individual, not a person. I appear here today as the settler, agent, not the person, but the individual. And I don't think I should have you understand the
So
difference
you're the
between a
settler,
person and an
you're the
individual.
agent, and you're the individual, but you're not the person. Is that correct?
Correct. Correct.
That is the exact moment the judge realized he could mess with not David Hall by using his own delusional mind games against him as he set his bond.
Here's what we're going to do. The settler, the agent, the individual, and maybe even the person, David Hall, has been charged with DUI. DUI while the settler, the agent, and even the person, David Hall, was on was out on bond on 2 cases, 1 felony and 1 misdemeanor. So today, the court's going to set the settler, the agent, the individual's bond, and even the person's bond today on count 4 at $10,000 because the settler, the agent, the individual, and the person has not stopped driving, even though the settler, the agent, the individual, and the person continues to drive without a driver's license. Both cases will cause the settler, the agent, the individual, and even the person, David Hall, not to be able to be released from the Broward County Jail until further notice of the court.
After hearing this, the real David Hall decided to make a surprise appearance, and the judge did not hesitate in reversing the roles.
May I post bond, sir?
Well,
is there any other?
Are you asking me as the settler, the agent, the individual, or are you asking me as the person?
Sir, I'm asking as the individual appearing before you today about this matter.
Well, the
Do I
individual.
have? I'm not the person, sir.
Okay, when
I am
you
not
see the person,
person.
David Hall, tell him he's not leaving jail either, all right?
Sir?
By the way these citizens go about their lives without any care of the law, increasing their bond is the least a judge can do to teach them a lesson. And this guy secured a spot in jail with a single word. Meet Nasir Brown, a Jefferson County resident facing domestic violence charges and injury to a child. From the beginning of his hearing, the judge advised him that it was in his best interest to drop the Sovereign Act, and he definitely should have listened to her.
Here today.
You're appearing here today?
By special appearance.
Okay, what is your name?
Third party intervener on behalf of court official legal entity not separate.
So here's the thing. If you don't tell me your name, I'm going to put you in custody for not cooperating this morning. I'm not going to, hold on. I understand what you're doing and what you're trying to do. It's not going to help you a single bit in court to try to play these games.
That's relative.
Despite the clear tension in the room, the judge still tried to offer him fair treatment by guiding him through the process, but Brown already had his mind set.
So here's what I'm going to do, Mr. Brown, is I'm just like everyone else. I'm resetting your case about 30 days to give you some time to try to hire a lawyer. You need to try to get someone hired before the next court date. If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order, and you would go back to jail. Do you understand? I'm sorry?
Overstay.
Say it again.
Overstay.
You overstand?
Yes.
Okay. What does that mean?
Overstay.
Do you understand what I'm saying, sir?
I'll oblige.
You'll oblige.
Oblige.
You just determined to use different words and be difficult, aren't you?
See, overstand is a term commonly used by sovereign citizens to avoid entering legal agreements, but it isn't a very liked word by judges, so every time he used the term was another nail in his coffin.
So as a condition of your bond, did you have a condition that you were not to have any contact or communication with the complaining witnesses in each of these cases, right? Okay, and so I want to make sure you understand the importance of that, and that if you do have any contact or communication with either of them, it would be a violation of that bond condition. If I find out, your bond would be raised and you would go back to jail. Do you understand that as well? You overstand. I'm going to guess that overstand is even better than understand. So you definitely know what I'm talking about, right?
I bet that he also overstood when he got his bond increased to $15,000 over risk of flight and contempt of court. Even with a lot of verbal trickery, it usually takes a lot for a judge to actually. At the defense table sits Trevor McLeod from Sheboygan County, facing a charge on marine DUI and obstruction of justice. These charges are usually considered a misdemeanor, but due to the fact that he's a habitual offender, McLeod faces a possible sentence of up to 3 years. And despite the risk, he still chose to defend himself, a decision that he would end up regretting shortly after. But it did not take long before McLeod began acting in contempt of court, leading to the judge issuing multiple warnings.
Do you understand the maximum penalty for the charges against you?
Well, I don't even really understand why I'm here.
Do you understand that the maximum penalty that you could face for the charges that you're here for is up to 3 years in prison and or $1,000?
I don't understand the nature and cause of the action against me, so I
What is it that you don't understand? Do you not understand how long 3 years is, or how much the fine is that I've articulated? Can you tell me what it is you don't understand?
the nature and cause of the action against me.
The judge managed to explain the charges to him for a few minutes, but once his patience ran out, he resorted to a more hands-on explanation.
Let me make this simple for you. Sure. I'm going to ask you this question one more time. One more time. Two things are going to happen. You are either going to answer my question, or I'm going to hold you summarily in contempt, and the court officer will bring you to a jail cell, and we'll talk about it tomorrow. You understand that? Do you, Mr. McLeod, understand that the maximum penalty for the charge against you is 3 years in prison and or $1,000 fine?
I don't understand the charges.
Mr. McLeod is in contempt of court, taken into custody.
Really? God's sake. Protecting my rights is what you're saying.
If only they'd employ the same energy they use to obstruct justice in keeping their mouth shut, judges would have a much easier job. If you want more content like this, one defendant got dragged out of court for gross contempt, and another one got awarded 100 days in jail for running his mouth. So click this video to see 10 times judges had zero tolerance for disrespect.